This is the old Dallas County Jail, now demolished. Every cell block had a large chalkboard listing all the prisoners and their offenses, such as perversion. Alvin Buchanan, a 37-year-old man, was a prisoner there in 1969. He was caught having sex in a public restroom in February that year and again in April. His sex partners pleaded guilty to misdemeanors and paid a fine, but Buchanan was charged with sodomy, a felony. He was tried in May, sentenced to 5 years, and landed here. In a letter to the Los Angeles Advocate, Buchanan explained what it was like. Prisoner life is not easy. I am in a cell with all admitted homosexuals in the Dallas County Jail. Sometimes I have been beaten by other prisoners and threatened by jail guards. Sometimes they bring horny heterosexuals to our cell to get their rocks off. Some of the things I am forced to do while I am in jail are unspeakable. Buchanan believed that he was being treated unfairly and that Article 524, the law he was convicted of breaking, was unconstitutional, and he fought it all the way up. It was the first sodomy case to reach the Supreme Court. Let me tell you about Article 524. When Texas broke away from Mexico in 1832, it didn't have a sodomy law. Sodomy was not illegal in Mexico. In Spain and its colonies, sodomy was a sin, not a crime, and was dealt with in the confessional or by the Inquisition. When Texas joined the United States in 1845, it adopted laws like those of the other states, but it didn't get around to outlawing sodomy until 1860. Then, like the other states, it just took language from English common law, the Buggery Act of 1533. Here it is in a typeface easier to read. That law prohibits the detestable and abominable vice of buggery, but it does not say exactly what that vice is. The Texas judges hearing actual cases regularly dismissed sodomy cases because the statute was vague. The legislature acted to remedy that by specifying sodomy as anal intercourse, but that left oral sex lawful, and they wanted to prohibit that as well. In 1943, after much deliberation, they wrote Article 524 of the Criminal Code. Article 524 tells you exactly how to commit sodomy, which parts go where, and with whom, namely, any human being. It was sternly enforced. In the 6-year period from 1963 to 1969, the year Buchanan was arrested and convicted, the Dallas police reported 425 sodomy arrests. And Dallas County is only one of the 254 counties in Texas. Buchanan had no money, but he found a champion, a 26-year-old gay lawyer named Henry McCluskey, who agreed to represent him for no fee. They sued the Dallas Chief of Police and the Dallas County District Attorney for violating the 1st, 4th, 5th, 6th, 9th, and 14th Amendments to the Constitution. The Dallas Morning News gave a very straightforward account of Buchanan's argument. Members of the Vice Control Division of the Dallas Police have concealed themselves in the attics, ventilator, shafts, and woodwork of the restrooms, the action says. It says the purpose of such police activity is to inhibit the freedom of homosexuals to be treated as their heterosexual equals. The suit was called Buchanan versus Batchelor. The defendants were Charles Batchelor, the Dallas Chief of Police, and Henry Wade, the District Attorney. McCluskey came up with a brilliant argument. He enlisted a gay-friendly married couple to join the suit, saying that they feared prosecution because Article 524 specified any human being, which would be straight or gay, married or single. The constitutional issue was the violation of married people's right to privacy. Justice Hughes agreed. Wade appealed, arguing that having a married couple as parties changed the case. The appeal was heard by a 3-judge panel, and Article 524 was found to be unconstitutional and the arrest illegal. But Buchanan was still in jail. McCluskey petitioned criminal court judge Ed Cossett for his release. Ed Cossett was an old-school politician who served 40 years on the criminal court, and he just outright refused to release him. This was his reasoning. Whether sodomy and homosexuality should be a crime or a disease, the confessed practitioners thereof should be isolated from the society upon which they prey. Meanwhile, Henry Wade appealed the district court ruling to the U.S. Supreme Court. In April 1970, after 10 months behind bars, Buchanan was still in the Dallas County Jail. The national press did not pick up the story, but Ed Jackson was covering it for the Advocate. Buchanan wrote Jackson this letter from jail. He says he is innocent and thanks the people who have sent him $73 in aid. He notes that even as he wrote, there were scores of sodomy cases pending in Texas. And it was here that he described the way he was being treated. Beaten, threatened, raped, unspeakable things. By July, Buchanan was out of jail, but destitute. To get his client released, McCluskey had posted bond of $5,000, contributed by well-wishers in the gay community. Bo Stewart, who edited the newsletter of the Metropolitan Community Church, did a telephone interview with Buchanan and published it in Gay, a New York newspaper. Buchanan told Stewart more about the conditions he had known in the Dallas County Jail: forcible rape, sadistic beatings, 3 teeth knocked out, many black eyes, stomach ailments. The chief jailer, E.L. Holman, objected to Buchanan's contacts in the gay community, and he threatened to put him in the hole. Darkness and isolation and a bread and water diet for 30 days. That's what he would get unless he wrote to MCC pastor Reverend Troy Perry, telling him not to send church publications. After that letter, he was not allowed to write Perry at all. With the bond posted, Buchanan was out of jail but not out of trouble. While Wade's appeal worked its way up to the Supreme Court, Buchanan had to live. Because of all the publicity, he couldn't get a job. His hotel room cost $4 a day, and he also had expenses for food and necessities. Funds were desperately needed, Bo Stewart told his readers. Slowly, the appeal worked its way up to the High Court. McCluskey got help with briefs from the ACLU and Frank Kameny of the Mattachine Society. The authorities did not really want to police married couples in their bedrooms, so Texas did not defend the any human being language of Article 524, but argued instead that the state did have the right to regulate the sexual conduct of unmarried persons. And in March of 1971, the crushing resolution. Wade won, Buchanan and McCluskey lost. The decision was on a question of jurisdiction, not on privacy rights or the merits of Article 524. Chief Justice Earl Warren voted to hear the case, but the other 8 justices all said the district court had exceeded its authority when it declared the law unconstitutional. They reversed that decision and sent the case back to the district court. So the Texas sodomy law stood, saying, "I intend to enforce the law." Henry Wade announced 30 new arrests for violations of Article 524. The Dallas police assigned 7 vice unit detectives to restroom surveillance. Buchanan's bond was revoked, and he was sent to serve the remainder of his 5-year sentence at the Texas State Prison in Huntsville. In July of 1973, Henry McCluskey was found dead, with his hands tied behind his back and shot twice in the back. He had been drugged and kidnapped and forced to write a check. His office had been ransacked and the telephone ripped out. With McCluskey gone, Buchanan lost his link to the gay activist world. I don't know if he got any time off for good behavior or had to serve every day of his 5-year sentence. After his release from Huntsville, Buchanan moved to the small town of Poolville, Texas, near Fort Worth, where he had family. He found a job as a short order cook. He died there in 1999 at the age of 61, survived by a daughter and 2 grandsons. This is his obituary. This is his tombstone. Even though Buchanan's challenge did not succeed, Article 524 did not long survive. The legislators decided to drop the antiquated sodomy language and the any human persons provisions and draft a law to do what they really wanted to do, outlaw gay sex. The new legislation was Article 2106, and it took effect on January 1, 1974. The offense was no longer called sodomy. The new law was called the Homosexual Conduct Law, and it prohibited any kind of sexual intercourse between members of the same sex. It was reduced from a felony to a Class C misdemeanor, but this was not from a spirit of leniency. The lower penalty made it easier to get convictions and much easier to get guilty pleas. Article 2106, in its turn, ended up in the Supreme Court 30 years later in the Lawrence versus Texas case. But that's a story for another clip. Finally, let me acknowledge the researches of Wesley G. Phelps, a historian at the University of North Texas and the author of Before Lawrence versus Texas, my main source of information in this clip.